Russell County Sheriff's Office for the month of October had 451 calls for service, for 25 arrests, 10 domestic for 91 traffic stops. We had 25, 10, 45 accidents with no injuries, 1 accident with injuries. Had 22 motor assists, 5 alarm calls, 6 animal complaints, 1 shots fired complaints, 16 suspicious person complaints, 18 welfare checks, 5 juvenile complaints, 251 other calls. We had 3 Adonta transports, 3 on Eastern State. Had 99 court papers served. Had 3 juvenile summonses, 24 criminal summonses, 53 criminal summonses, 13 subpoenas, 5 eviction notices, 1 EPO. And we had 106 prisoner transports. We drove 1,731 court transport security miles. Had 241 vehicle inspections. Had 19 concealed deadly weapons permits issued. Month of October, Sheriff's Office, proud of my girls, collected $9,495,372.69 property tax.
Motion made by Magistrate Waddell, second by Magistrate Richard to accept the sheriff's report. All those in favor signify by saying aye. Aye. Any opposed, same sign. Next is the treasurer's monthly settlement report, May transfers. Y'all have those in the packet.
I'll make a motion to accept.
Motion made by Magistrate Garner, second by Magistrate Richardson to accept the treasurer's settlement report. All those in favor signify by saying aye. Aye. Any opposed, same sign. Next on the agenda is to transfer $2,000 to the Russell County Animal Welfare Spay and Neuter, for the Spay and Neuter grant. I have to say that you've got a thing in your packet, but I think we're seeing some results in the county of what all they've been doing, and they just opened up a full-time spay and neuter clinic at the DVA. I'm sorry. They were doing a mobile unit, and they could only do it during the months that it was warm, because they did it outside. But now they went in and they basically set up an operating room in there, and they're doing it all the time. So I think it'll be good for our county. I just need a motion to let me do that.
I'll make a motion.
Motion made by Magistrate Waddell, second by Magistrate Wilson. All those in favor signify by saying aye.
Aye.
Any opposed, same sign. Next on the agenda is Attorney Christopher Davenport on behalf of Round Trip LLC Solar Farm.
Thank you, Judge Executive, Magistrates. My name is Chris Davenport. I'm an attorney from Bowling Green. And first of all, thank you for letting me speak to you. Very short notice. Got retained by Round Trip LLC and a few of your landowners here in Russell County very late last week. Found out that this second reading was on your agenda. So got some correspondence out as quick as I could to Judge Marcum. And again, I appreciate the opportunity to speak. Didn't have to do that. And that's much appreciated. Again, my name's Chris Davenport. I'm from Bowling Green. I'm sure none of you ever heard of me. I practice a firm called Broderick and Davenport. Much of my practice is land use, planning and zoning. I've been retained, as I said, by Round Trip LLC. That is a solar farm developer that's been active here in Russell County for a couple years. They have a number of leases and options in place. I have no doubt that the magistrates, you're aware of that. Most likely, you became aware of that through if the process usually plays out like it does, various neighbors became aware, and probably started the process with this body of encouraging you guys to take some action with regard to that. I have been involved in other counties. This is I'm sure y'all do know, a very pressing matter for a lot of counties. I've been involved in Lincoln County. I've been involved in Garrett County. My partner's been involved in Simpson County and Hardin County. Barron County's going through much of the same discussion. So this is not necessarily unique to Russell County. These debates have been going on for probably a couple years now, and we're seeing a lot of this come to a head. I basically set out my position with regard to your proposed ordinance in your letter that I sent to you. I hope you all have all received that. And let me first start out by saying the purpose of that letter was to make sure you all understood, before you consider any further action on this ordinance, what the position of my clients are. I'm sure that you've heard in various meetings in the past that there are landowners that don't want to see this ordinance get passed. I'm sure you're hearing from neighbors that they want this ordinance passed. What you may not have heard in a way like I've tried to lay out for you is what the legal debate is here. Okay? Russell County does not have a zoning board. You all know that. You've never adopted a comprehensive plan. You all know that. The question becomes, and you may have seen this out of Caldwell County, you may have seen it out of Breckinridge County. The question becomes, what type of ordinance, if any, can you all pass that doesn't run afoul of KRS Chapter 100? That is the chapter, that's the statutory scheme in our state legislative statutes that discusses planning and zoning. I'm sure you've been told by Mr. Shearer, Mr. Byram, that you can't enact a zoning ordinance if you haven't adopted a comprehensive plan, if you haven't joined a planning unit. So a lot of counties have tried this, and they've tried to create a similar ordinance, and they say, this is not a zoning ordinance, we're going to call this something else. We're going to say this is under Chapter 67. I'll just simply tell you this, that issue is going to be decided pretty quickly by the courts of appeal. Okay, Breckinridge County last week took that ordinance up. The solar development up in Pardonsburg, they took that up on appeal. The decision Caldwell County was not appealed. So there's at least going to be one. I have provided you all the complaint that I filed in Garrett County, and I'm going to get to that in just a second. My goal is, if we can't get that resolved, is I think Garrett County will probably fall in line with some of these other counties, okay, as far as what happens at the appellate level. But the reason for my letter, first of all, is just to make sure you guys are aware of this. That the debate here is not just simply, do we think solar farms are good or solar farms are bad? There are rights that my clients have that I want to make sure you all are aware of. And if you're aware of the Caldwell County case, and if you're aware of the Breckinridge County case, nobody in those cases made those circuit courts aware of KRS 100.253. In my letter, I talk about legally non-conforming, what that means. We call that typically grandfathered. You may have heard the phrase, well, so-and-so's grandfathered in because they had something before the law was passed. Okay? What your proposed ordinance does is, it says that Russell County is going to exempt from this ordinance. They're going to grandfather in people who have, quote, began physical construction. I'm here to tell you, I think that position is completely contrary to what established case law in Kentucky is. Okay? Again, I know you folks aren't lawyers, and I know Mr. Shearer's unavailable, and I hate to hear of that circumstance. But in Kentucky, as far back as the 1940s, out of Frankfurt, the Supreme Court has said, even applying for a permit, nothing more, is sufficient to be grandfathered in. That's the case of Darlington versus Frankfurt, I put in that letter. Okay? And the reason I want y'all to know that is, this body cannot change state law. I think you all understand that. There are certain areas where state law controls. And I don't think this body has the ability to say, well, we're going to exempt in, you have to have physical construction to be exempted. I think that's contrary to what the law is in Kentucky. Those other counties have also not addressed Kentucky Constitution Section 19, which says no law, we call that the ex post facto provision of the Constitution. And what it says is no law can eliminate or minimize existing contractual rights. What I see is happening across counties is there isn't a lot of debate going on about these different provisions. And I've done zoning work for 23 years. And every zoning case I've ever been in front of, whether it was a fiscal court, a city commission, or a zoning board, there is a tendency sometimes to acquiesce with the most vocal group. And what I'm here today is to suggest to you is your obligations are beyond that. My clients have rights, and we're just asking that those rights be recognized, okay? What I hope comes out of this, number one, Judge Marcum, you asked how much time I needed. I said 30 minutes. There's no way I'm talking for 30 minutes unless you all have questions, okay? And I'm happy to answer questions. I want this to be a dialogue. I talked with my client on the way here, coming up the Parkway, a crazy amount of snow for some reason. I talked to them on the way here today. And they reiterated to me, we still want to work with Russell County. Chris, don't go over throwing bombs, okay? That's not what I'm here to do. Now, I've given you the Garrett County case because that's what I'm trying to avoid, okay? I went to Stanford, Lincoln County about a month ago. I talked to them in this same manner. After I got done talking, they went to the executive session. They came back. They didn't get rid of their ordinance, okay? But in Lincoln County, they've got a zoning board. They're a little different from you all. There's arguments in this case that didn't exist in that case. They have a zoning board. They have zoning regulation. But at least they came back out and they exempted people with existing contracts. And I think by doing that, they complied with that statute 100.253. And I think we've avoided in Lincoln County what I'm afraid is happening in Garrett County, and what I think is happening in Breckenridge County, and what I think is happening in Caldwell County and these other counties. That's what I'm trying to do today. I'm trying to avoid that. But I want you to understand what's the other side of the coin is if we can't get this worked out. So, again, I didn't get this opportunity in Garrett County. When I got hired by those folks about a month ago, their ordinance was already over a year old. And so Garrett County, we're having to take a different tactic to try to address that. So I don't want to belabor the point. I do understand from Mr. Byram that maybe you all are seeking some outside counsel with this. I think that's wise. I tell my kids all the time, I got a 19-year-old, a 17-year-old, and a 12-year-old. So I'm kind of in the thick of it. But I tell them, when you're going to make decisions, at least avail yourself of all the information that you can before you make them. Because I think we tend to make better decisions when we do that. We don't make very good decisions when we just reflexively or instinctively think, well, I'm just going to do that. I don't want to hear anything else. I don't want to hear what this lawyer from Bowling Green says. If you all are considering other counsel about this, I would encourage you all to hit a pause, take the opportunity to talk with other counsel, get their advice. I'm not saying I ain't ever been wrong. We're all wrong. I'll be wrong sometime today. I do mean, though, to relay to you the conviction that I think I'm right about this. Some of this law is not complicated. It's been around a long time, and it's pretty clear. While this board has the ability to take certain action under 67, Chapter 67, that doesn't mean Chapter 100 doesn't exist. And you've got to consider both of those statutory schemes when you make a decision on this. I know Russell County, for what I've heard, really has no interest in planning and zoning as far as a countywide zoning. I come from Warren County. We have zoning every inch of the county. And trust me, there's plenty of people in Warren County wishes we didn't have that. But we do. My suggestion to you is be careful about dipping your toe in the zoning ordinances when you haven't complied with KRS Chapter 100. So again, you got a couple things you could do. I know when I sit down, I see on the agenda, there's going to be a group, a person or persons are going to stand up here and they're going to tell you all the reasons why solar is terrible, why solar is bad. I'm not here to debate solar farms, okay? I'm not doing that today. This is not a zoning hearing. I'm here to make sure you're aware of these statutes and the rights my clients have, and you think about them before you act any further. You all know only the second reading is the one that's important. Whatever y'all have done up to date doesn't mean anything. I don't know if you even took a vote at the first reading. You don't have to. It's only the second reading that's important. And so you've got a couple options. You could, after I'm done talking and these representatives are done talking, you could take a vote on that ordinance. If you do, I'm going to strongly suggest you turn it down right now. You could table that, okay? Talk to other counsel that you have before you take that vote. Maybe they can have a dialogue with me. Maybe this can still be worked out. Again, that's my client's number one goal here, is to try to see if there's some middle ground before we all go to guns, okay? Third option, you could go to executive session today and discuss this before you take a vote. Assistant County Attorney can help you with that. Really, what I'd suggest you do, though, is you just pump the brakes on this. Make sure you've got all the information you can before you act. And I'm welcome to talk with, whether it's Mr. Shear, Lord willing, or Assistant County Attorney, or anyone else y'all might have. That's the directive my client's giving me right now. That's what they'd like to see happen. So, Judge Executive, I'm happy to answer any questions y'all might have, if I can.
Anybody got any questions? Maybe after we do the next year.
Yeah, as soon as they get done talking, I think that's what we need to do.
That's what, I'll just tell you, that's what Lincoln County did.
Yeah.
And I think in Lincoln County, I brought some stuff to their attention they weren't aware of, and I'd asked them to think on it, and that's what I'm asking y'all to do. I know you've seen the complaint against Garrett County, okay?
It would help to let these people over here, over the solar farms that's not wanting it, it would help for them to have the letter that you sent us. That's what my personal opinion, and right here is some landowners up here, and I've known them since I was a kid. And, you know, they don't want to hurt, no, they don't want to do nothing to anybody in this county.
And, you know,
Heck, I've known him for all my life, and, you know, Edmund's right there by him, you know.
yeah, and Commissioner Gardner?
Yeah.
Magistrate Gardner, in my experience,
It don't matter.
sometimes,
That makes me feel better, we call Gardner.
when I'm in front of fiscal courts or legislative bodies, I'll have clients that they're getting ready to do something my client doesn't like,
Yeah.
you know, and my client will say, well, they're just out to get me. And then I'll be representing people and they're doing something that my client wants done. They say, well, they just get it. The truth of the matter is, the vast majority of legislators like you all are trying to get it right.
Well,
And you've got multiple people with multiple opinions, and I understand that.
we have friends on both
Sure.
sides here. And I mean, when did you come to rural Kentucky, 90% of the people is like family. I mean, and if something happens to somebody in this county, everybody in the county, you know, they'll have benefits for them and, you know, pinto beans. And a lot of people don't even know what pinto beans are, but they're pretty good. But, you know, we have a big turnout for it.
Sure.
But that's neither here nor there, but everybody wants to help everybody in this county.
And I guess the point I'll make, and I'll sit down as soon as I say this and let y'all hear from other folks.
Yeah.
You might have a constituency in your all's county that says, you know, at 18 years old, driving's not safe. And they might come to you all and say, hey, we need to raise the driving limit in Russell County to 20 years old. And that may be a smart decision, but the Kentucky laws say you can't do that. Okay? And what I'm trying to submit to you is trying to put an ordinance that I believe is a zoning ordinance when you don't have a zoning board, and trying to say, well, we're going to only exempt people in that's began physical construction, to me is like trying to pass a 20-year-old driving minimum in Russell County. It wouldn't hold up against the existing state law, and that's what I'm trying to point out today. I appreciate your all's time. Thank you very much.
All right, we've got 13 minutes, so if the opposing side wants to come up.
Thank you for giving us some time to speak. We really appreciate your attention. Just quickly, I'll give a breakdown of a little bit of my background. My name's Elena Grider. I've grown up in Russell County my whole life. Chose to stay here after college, and has been one of the best decisions I ever made. Recently, I bought a home on Bottoms Road in District 4 this summer, actually. Some of you were at the first meeting where we requested this ordinance be drafted. You might remember Brian McElroy speaking, and in his discussion talked about how his family farm recently owned a home. His sister and her husband owned a home on Bottoms Road. They sold that home to me. He mentioned the single mother. I am that single mother. It is a beautiful home, and it is a beautiful property. That property sits looking directly at Bottoms Road and over a large field. That particular property is 150 acres. That property is the very center of what is planned to be a 500-plus acre solar farm. And so while this particular project is very near and dear to me, it is literally at my front door. And so it is very close to a lot of us in that particular area. This particular project is. It is near and dear to our hearts. But that being said, it is not a one-district issue. You all know that. There are 5 solar projects in the works across the county. We're talking more than 5,000 acres being taken that is workable, croppable farmland from our county. That is farmland that may not be farmed essentially today, but could be at a later date. And because it is a countywide issue, there are residents, citizens in every district that are genuinely concerned about this. Also, because it is a countywide issue, I called all of you magistrates. That is my duty as a voting citizen to speak to you. And that is a responsibility I do not take lightly. First of all, I want to thank each of you for answering your phones and speaking to me. That matters, that you answered your phone and you took the time out to talk to me. More than that, you were honest with me. That matters. So thank you. I want to take just a few minutes to encourage you all. And then if the court will allow, I'd like to take just a few minutes to address the public as well. Encourage them for a minute. I think we could all use a little encouragement these days. I really appreciate, all of us really appreciate the fact that you have taken your time out to investigate this issue, to become informed. Kevin especially took an amount of time that most people wouldn't. He knows what his responsibility is, and we know that he has met that responsibility. He has looked into all of these issues and spent time diving into those things. We know that if we were honest, all of us here would probably not willingly choose to find ourselves in the position you all are in. But you have chosen that, and we want to thank you. You are essentially the gatekeepers of Russell County, and what you do matters to us today and for generations to come. Because this issue we deal with today is just one issue. You all deal with so much day in and day out simply because you are elected officials. You do not take that lightly, and we appreciate that. Including you, Randy. You have a lot on your plate. I didn't get to speak with you. I tried to reach out, but we didn't make contact. I know your heart, and I appreciate you. I want to take just a minute also to address the public, simply to say that your voice matters. Your concerns are valid. The best way to have your voice heard is doing what you're doing today, to stand up and speak for your concerns. You've stayed informed. You've made your voice known. Might I remind you that another good way to have your voice heard is to vote in every election. But voting is just the beginning. I would encourage you to talk to your neighbors, your friends and your coworkers, or your relatives that live in other districts. Because although I live and vote in District 4, it is very important to me who is elected in all the other districts, because it takes a collective body to make decisions, important decisions, like we're here today about. So I would encourage you to stay informed. Speak out. Know what your neighbor's concerns are. Know what the guy down the street in another district is concerned about. That concern may only be his today, but you wait, it will be at your door soon. If we do not speak up, we risk the future of our county. We risk the future of other generations. My son, his future children, your grandchildren. It is at risk. And I want to encourage you in that. Specifically, I did not intend to say this part, but I feel led remind you that regardless of the situation, this is heavy on a lot of our hearts. This is weighing on a lot of us day in and day out. But I feel led to tell you that the Lord is on our side. I don't mean our side as our group. I mean, the Lord is for us. The Lord loves all of you. And He is seeking you, and He is drawing you. And I don't know what you're worried about. I don't know what your fears are today. But He loves you, and He has good plans for your life. Do not let this issue become your takedown. Do not let this issue burden your heart. Be lifted high. He loves you, and He is for you, every single one of you. That being said, I really appreciate Mr. Davenport coming today. That is valuable information. We would like to see the letter you sent to the magistrates. That would be great. Also, you'll notice he mentioned that, I believe it was Garrett County, is a little bit farther along in this process, and he mentioned he was having to take other steps. Let that sink in. They have an ordinance in place, and they are having to stand up for that ordinance, yes, but it is very difficult for him to do so. It's very difficult for his law firm to do that because they have something in place. He said that himself. He's having to take other measures. That means it's not a cakewalk. That means we have grounds to stand on. And as far as I think I can speak for everyone else, we're happy to allow the courts to decide legally the way the process is supposed to work. These issues of concern should have been addressed at the first reading. That's what a first reading is for. So while we respect everyone's property rights, we respect the right of these landowners, we have rights as well. We hope that you will vote in accordance with that. Now, mind you, when I spoke to all of you, in essence, most of you generally said, I work for the good of the people. We believe that, but you have an opportunity to align your words with your actions today. The people of Russell County deserve a clear decision. As it is heavy on a lot of hearts, we do deserve a clear decision today, and we believe that you will make the right one. Thank you.
Yeah, just a quick reply, if I may, Judge Marcum.
Yeah, they've got,
Oh, I'm sorry.
there's some more time though.
Whenever they're finished, I won't take any but a minute.
Okay.
I'll just make mine short and sweet. I just hope that if he's correct in his standing, that the solar company will abide by the Kentucky state law as far as the setbacks and the noise ordinance that's already in place with the state, okay, without any deviations. The other downside to this is we can't let just a few landowners and a few investors dictate whatever to the rest of the community. I mean, say there's even 50 investors or landowners, there's thousands of people who are against it. We can't let, those few dictate the rights of the others. Okay, that has to be taken into consideration. Maybe we should consider a zoning commission. If we haven't accepted that, maybe we should, just for these reasons. So this type of argument, or not argument, but conversation wouldn't happen. And my other aspect to this is, if this does go through, I'm gonna need to find out who's gonna pay for the diminution of value of my property, because I'm gonna lose a lot. Okay, thank you.
So I just want to respond to something Ms. Grider said. Before I do that, I think the gentleman that just stepped up made a really good point. And he talked about the state statute, the setback. That's in chapter 278. And that's a point I should have made earlier. If anybody suggests that it's just a free run for solar farms without counties acting, that's not consistent. The state has addressed some of these issues in chapter 278. And nothing you all do gets rid of 278. I mean, my client has to abide by 278 regardless of what you all do. It's not a complete Wild West free-for-all. As for what Ms. Grider said, she made a statement that somehow my work is more difficult in Garrett County. Let me be frank, that's not the case at all. It's probably easier for me to talk to a circuit judge in Garrett County than it is magistrates who aren't lawyers. The difference is, in Garrett County, those clients have sued those magistrates, in part because the magistrates understood these laws but acted anyway. That's the main reason I'm here today. And I know sometimes in Lincoln County, here's what they told me before I walked up there. They said, well, we'll just let the court figure it out. And when I pointed out to them that under Kentucky law, if a fiscal court or any elected official acts contrary to known rights, y'all don't have immunity for that. The immunity you enjoy when you all make discretionary decisions, but you can't run over people. You can't say, well, they have a right to be grandfathered in, or we don't have a zoning ordinance, and therefore people can do with their land, right? I mean, Ms. Grider doesn't have to worry about zoning her land, her property. If y'all act contrary to that, the immunity goes away. And so I don't want to see it come to that. I'm still hopeful Garrett County works out, because I never got to have that discussion over in Lancaster like I did in Stanford. When these same arguments were presented in Stanford, that board did something else than what they were intending to do. And they expressly recognized people with existing contracts. And so, again, you got options. At a minimum, if you think about moving forward, I would urge you to exempt in existing contracts and not put the standard that if you began construction, because that's absolutely contrary. Now, whether you'd still survive the lack of a zoning board, that's another issue. But at a minimum, I'm going to ask you to try to table this, talk to your attorneys, get information, and don't put yourself in a box you can't get back out of. Again, I appreciate y'all's attentiveness today. Thank y'all very much.
Thank you. You want to make a motion? We can make a motion.
We go.
What's that KRS? What's that KRS for? Got a motion for an executive. Need a second. Got a motion from Terry, a second from Zach. All those in favor of going into executive session, signify by saying aye. No.
Magistrate Skaggs?
No.
Magistrate Richardson?
No.
We can't hear.
Magistrate Wilson?
Yes.
Magistrate Garner?
Yes.
Magistrate Waddell?
Yes.
So we're going to executive session.
Oh, yeah, you go into executive session. Thank you.
I'll make a motion, we can have an executive session.
Second.
Hold on a
Let she
second.
back.
Motion made by Magistrate Skaggs, seconded by Magistrate Waddell to come out of executive session. All those in favor signify by saying aye. Aye. Any opposed, same sign. Yeah. We'll get you something. All right. Come out of executive session, no action taken. All right. Mr. Byram here is going to read the ordinance for the second reading.
When they find it again, I had two different ones, and
Here's my copy. I think it's the same.
Russell County Fiscal Court Ordinance Number 25-10, an ordinance of Russell County Fiscal Court establishing regulations for solar energy system installation in Russell County, Kentucky. Whereas the Russell County Fiscal Court, in pursuance of its powers and duties vested in and by the Commonwealth of Kentucky, addressing and establishing minimum setback screening and decommissioning requirements for solar energy systems installation. And whereas the Russell County Fiscal Court upon thorough review and deliberation has determined that it is in the best interest of the public to implement a new ordinance to better address the contemporary needs and interests of both the county residents and the solar energy systems as defined herein, and whereas pursuant to KRS 67.083, the Russell County Fiscal Court is granted the authority to undertake all necessary governmental actions for the welfare of the county, and specifically is endowed pursuant to KRS 67.083 parentheses 3 parentheses H and KRS 67.083 parentheses 3 parentheses E for the regulation of commerce for the protection and convenience of the public, and with the powers to promote and conserve the county's natural resources, including but not limited to soil and wildlife, to safeguard the livelihood and well-being of its residents. Whereas the new ordinance is envisioned to embody more effective measures for protecting and conserving the conservation of the county's natural resources, thus fulfilling the mandate as outlined in KRS 67.083 parentheses 3 parentheses H. Whereas KRS 278.718 became effective on January the 29th, 2023, and further provides that an ordinance, permit, or license issued by the local government and enacted under the provisions of Home Rule under KRS 67.080, 67.083, 67.850, 67.922, 67A 060, 67C 101, and 82.082 shall have primacy over the provisions, including setback requirements set forth in KRS 278.70, 278.704, 278.706, 278.708, and any conflict between an order of the board and the local ordinance. Permit or license shall be resolved in favor of the local government ordinance, permit, and license, and whereas the Russell County Fiscal Court finds it necessary and appropriate to provide reasonable safeguards which mitigate potential nuisances such as soil erosion, water runoff and erosion, large-scale loss of agricultural lands, and impacts to local flora and fauna, among other created by large-scale ground-mounted solar energy systems as defined herein, in order to protect adjoining properties and public right-of-ways. And whereas the Russell County Fiscal Court desires to exercise its authority pursuant to this subsection, now therefore be it ordained by the Russell County Fiscal Court and the County of Russell, Commonwealth of Kentucky. Definitions: a building, any structure having a roof supported by columns or walls and intended for the shelter, housing, or enclosure of any individual, animal, process, equipment, goods, or materials of any kind or nature. Merchant electric generating facility means except for the qualifying facility as defined by KRS 278.700 subparagraph 7. An electric generating facility are facilities that, together with an associate structures and facilities, A, are capable of operating at an aggregate capacity of 10 megawatts or more, and B, sell the electricity may produce in the wholesale market as rates and charges not regulated by the Public Service Commission. Solar energy systems, S is in the body of this, we parenthesis SES is an abbreviation of that. A device including its components and subsystems that collect solar energy for electric generation, consumption, or transmission, or for thermal applications. SESs are in turn divided into three types, depending on how the system is incorporated into the existing land use. Number one, integrated solar systems, integrated SES. As SES, where the solar materials are incorporated into the building materials such that the building and solar system are reasonably indistinguishable, or where the solar materials are used in place of traditional building components such that the SES is structurally an integral part of the house, building, or other structure. An integrated SES may be incorporated into, among other things, a building facade, skylight, shingles, canopy, light, or parking meter. Number two, rooftop solar energy systems, rooftop SES. An SES that is structurally mounted to the roof of a house, building, or other structure and does not qualify as an integrated SES. Ground-mounted solar energy systems, ground-mounted SES. An SES that is structurally mounted to the ground and does not qualify as an integrated SES. Ground-mounted SES are subcategorized as follows. A, small-scale ground-mounted solar system, small-scale SES, which is a ground-mounted SES with a footprint base of less than 2,500 square feet. Large-scale ground-mounted solar energy system, large-scale SES, means a ground-mounted SES with a footprint of more than 2,500. This term also includes a non-exempt SES that is irrespective of footprint size or conformation. Constitutes merchant electric generating facility as defined by the terms of KRS 278.700 subparagraph 2 and is otherwise subject to review and approval by the Kentucky Board of Electrical Generation and Transmission, citing decommission plans for ground-mounted SES. A plan prepared by a licensed engineer that establishes the party's responsibility for the decommissioning, the anticipated life of the project, the estimated cost of removal of the SDS and cost for restoring the land to its original condition and any other plan information required by the ordinance. I'll get it. Enlargement. To increase the size of the SEA footprint or relocate an SES footprint to an area of land not included as part of the original license approval, or any change which would exceed the scope, increased height, or decreased setback or buffer of the original license approval. SES enlargement does not include the repair, modification, retrofitting, or enhancement of a licensed facility provided with such repair, modification, retrofitting, or enhancement does not violate the terms of this ordinance or a condition of the licensee's approval. Exempt solar energy systems, exempt SES. An SES that is a facility or a municipal-owned electric system or public utility regulated by the Kentucky Public Service Commission or the Federal Energy Regulatory Commission, which is exempt from the PIC, TNNING, and zoning requirements under KRS 100.324. Non-participating property, any property that is not a participating property. Participating property is a property on which a solar system, SES, as regulated by the terms of this ordinance, is to be constructed in whole or in part. This includes any property for which the owners has provided their signatures on a written and recorded agreement explicitly consenting to be party to a license application for the construction of the SES. Such signatures shall constitute prima facie evidence of the owner's consent and or agreement to any terms set forth in the licensure's application, including the waiver of any setback requirements from non-participating properties and subsequently defined herein. Physical construction, SES facility, the excavation or movement of earth, erection of forms or structures, or similar activities undertaken in the construction of the SES facility. This form does not include any activity or construction undertaken prior to the issuance of all required certificates, approval, and permits, if any, as required under KRS 278 and other applicable state statutes. Responsible entity, the owner of the solar energy system and related improvements, irrespective of land ownership by fee simple title, license agreement, or any instrument. The responsible party is the applicant under the terms of this ordinance. SES footprint, an area calculated by drawing a perimeter around the upmost SES panels and any equipment necessary for the equipment to function, such as transformers and inverters. The footprint does not include perimeter fencing or visual buffers, nor transmitting lines or other portions thereof that are required to connect to SES in a utility or customer outside the ES perimeter. Setbacks. The minimum distance established by this ordinance measures from the property line of a non-participating property or boundary of public roadway or rail line to the nearest portion of the SES footprint or other regulated SES feature. The setback distance required by this ordinance is to be contained within the boundary of a participating property and is the minimum distance from a non-participating property or public highway or rail line boundary, that a SES footprint or other regulated SES feature is allowed to be constructed. Sitting boards regulating SES. An SES that constitute a merchant electric generating facility under KRS 278.700 subparagraph 2, the construction and siting of which is subject to review and approval by the Kentucky Board of Electric Generation and Transmission siting. A merchant electric siting facility is an electric generating facility or facilities that together with the associated structures and facilities are capable of operating at an aggregate capacity of 10 megawatts or more and sell the electricity produced in the wholesale market at rates and changes not regulated by the Kentucky Public Service Commission. Applicability. The ordinance and its requirements for licensure shall apply to the siting, construction, installation, enlargement, operation, maintenance, and decommissioning of the large-scale SES facility in an unincorporated area of Russell County, Kentucky. The requirements of this ordinance shall not apply to the following: A, integrated SES, B, rooftop SES, C, small-scale SES, D, large-scale SES where physical construction began prior to the effective date of this ordinance. Physical construction is completed within 2 years of the effective date of this ordinance. The SES footprint is not therefore cumulative enlarged by more than 5%. Number 3, license requirement and renewal license. Prior to the commencement of the physical construction or enlargement of a large-scale solar energy system, the responsible entity applicant must obtain a Russell County Solar Energy System license. Additionally, a renewal license shall be required co-commitment with the updating of the decommissioning plan as stipulated by Section 4D herein. All applicants and supporting documents of this licensure shall be submitted by the applicant to the Russell County Fiscal Court for a determination of conformance with the requirements of this ordinance. A request for licensure shall contain the following: A, an application for licensure shall include 1, the name of the applicant and owners of participating property if differed. 2, the street address and the tax map parcel number of the property for which the license is sought to include all participating property. 3, the current mailing address and phone number of the applicant and the owners of the participating property. 4, a copy of deeds and lease agreements for participating property. 5, a listing of the names, mailing address, and property address, including tax map parcel numbers of all adjoining non-participating property owners, to include all owners within 2,500 feet of the proposed SES footprint. 6, a written description of the proposed facility that includes a statement of conformance with the requirements of this ordinance. The signed statement of the applicant and all participating property owners attesting to the truthfulness and exactness of the information supplied by this applicant. Supplemental documents and exhibits shall include, number 1, 24 copies of the site plan drawn to a scale of no greater than 1 inch to 100 feet, which illustrates a vicinity map denoting the location of the proposed property, B, property lines of participating properties and adjacent non-participating properties. Properties public right-of-way and rail lines within 2,500 feet of the SES footprint. Due to scale, the information may be provided as a separate sheet at a scale of no greater than 1 foot to 300 feet. Required setbacks with plan notes detailing the minimum distance to be provided for the SES footprint to the boundary of non-participating properties, public streets, and rail lines. D, adjoining roads and points of proposed access to the facility. E, the proposed location of the buildings, parcels, inverters, transformers, and other on-site supporting facilities with a plan note detailing the height of such features. F, the proposed location of perimeter fencing with plan notes detailing height and setback. G, the proposed location of the vegetation buffer with plan notes detailing plant type, plant height, and anticipated mature height and the opaqueness of, and any additional site plans depicting or accompanying descriptions such may be required to determine compliance with this ordinance. Number 2, decommissioning plan and surety instrument. C, a statement of the proposed large-scale SES and conformance are pending conformance with the requirements of KRS 278.700, where the State Board of Electrical Generation and Transmission siting approval is required. D, fee entitlement for review and application. The Russell County Fiscal Court is hereby authorized to impose a fee for the review and processing of licensure applications. The amount of this fee shall be determined reasonable and commensurate with the services provided. The specific fee schedule shall be determined and established by the Russell County Fiscal Court at their discretion and formation through a duly appointed resolution. This fee shall be payable upon submission of the licensure application and is non-refundable. Within 60 days of its receipt of a complete licensure application, supplemental documents and exhibits, and for the Russell County Fiscal Court shall review and recommend that the application for licensure be, number 1, approved, number 2, approved with conditions or requirements, modifications, or denied, number 3, denied with cause stated. Such recommendations shall be recorded in the minutes of the court meetings. Within 30 days of receiving a recommendation from the Russell County Fiscal Court regarding a licensure application, the Russell County Judge Executive's Office shall, number 1, issue the requested license or without condition or modification as deemed appropriate, or, number 2, deny the license request, providing the cause for denial in writing. where a license is issued, it shall remain in effect unchanged, provided the applicant maintains compliance with the terms of this ordinance and the condition of the original approval. Upon the issuance of a solar energy system license, the Russell County Judge Executive's Office, it shall be recorded with the Russell County Clerk's Office to place notice upon all bona fide purchasers for value of the existence of such license. In the event of a denial, the Russell County Judge Executive shall provide the decision in writing, which shall be sent by certified mail with return receipt requested to the applicant. All participating properties and non-participating properties included within the application. Furthermore, the denial shall be published in accordance with the provisions of Chapter 424 of the Kentucky Revised Statute. Any aggrieved party by either the issuance or denial of a license shall have a period of 30 days from the date of the recording of the license to the publication of the denial of said license to file an action with the Russell County Court seeking judicial review. Specific requirements number 4. The following standards shall be the siting, construction, installation, enlargement, operation, maintenance, and decommissioning of large SES. Setbacks. The setback footprints shall set back no less than 2,000 feet from any non-participating property line and any right-of-way for public maintenance roadways or rail lines. Parameters, access, and screening. Access to the site must be controlled by a fence of at least 8 feet in height with a vegetation landscape buffer provided between the fencing and the property line. The fence shall be equipped with a screening to help shield the facility, and equipment from view. Screening shall consist of, number 1, an 8-foot fence, 8-foot tall fence, and a double row of staggered evergreen trees, a minimum 5 feet in height at planting and maturing to a minimum of 15 feet in height. Number 2, evergreen trees shall be planted exterior to the fence and shall be set back no less than 5 feet from the property line. 3, screening shall achieve an opaque, I have trouble with that word, it's opacity of 90% to a height of no less than 8 feet within 3 years of planting. Screening, number 4, screening shall be installed within 180 days of the start of the physical construction and shall be maintained until the decommissioning of the SES is complete. And 5, all unhealthy, dead, or non-compliant planting shall be required or replaced within 90 days of such occurrence. C, lighting. Lighting of a ground-mounted SES shall be limited to the minimum necessary for safe operation and shall be directed downward, incorporating full cut of features, and incorporate motion sensors where feasible. Lighting shall be designated to avoid light trespass. Nothing in this section is intended to preclude installation of lighting required by the Federal Aviation Administration. Decommissioning plan required. The applicant shall be responsible for a decommissioning plan prepared by a registered professional engineer at the expense of the applicant and updated not less than once every 5 years, containing the following. Number one, the anticipated life of the project and defined conditions upon which decommissioning will be initiated. Number two, the estimated decommissioning cost, including removal of the solar energy. 3, system and related foundations, pad, underground collector lines and roads, transmission lines, and the revegetation and restoration of the property, including soils, to be its original condition, and all calculations supporting the decommission estimate. Number 4, the manner in which the project shall be decommissioned, including provisions and a timetable, such timetable not to exceed 5 years, for the removal of the structure and foundations, and for the revegetation and restoration of the property to its original condition. Number 5, the manner of SES component disposal includes the estimated recycling value of components, and 6, a copy of any contract containing specific agreements regarding decommissioning. Subparagraph D, surety instrument requirements. The applicant shall provide a surety instrument in an amount and form acceptable to the Russell County Judge, Fiscal Court, upon recommendation of the court, sufficient to cover the cost of decommissioning the SES in accordance with the approval plan in the event the applicant defaults in its decommissioning obligations. The surety instrument shall be updated and revised in conjunction with the submitted decommissioning plan. These two stuck together. Not less than once every 5 years, a surety instrument shall be continuously maintained by applicant, the successors in interest, and/or assigns until such time as the large-scale SES is decommissioned and all disturbed areas are reclaimed, revegetated, and restored. The form and content of the surety shall be in accordance with the requirements of KRS 278.706, subparagraph 2M and 5, and shall name Russell County government as secondary beneficiaries. For projects with the SE footprint located within an airport approach zone or airport imaginary surfaces as defined by the United States Court of Physical Regulation, Federal Regulations, are within 1,000 feet of an accident potential zone, parentheses APZ1 or APZ2, the applicant shall complete and provide the result of a glare analysis through a quantitative analysis of potential impact, field test demonstrations, or geometric analysis of ocular implant, and consultation with the Federal Aviation Administration Office or airports, the Kentucky Airport Zoning Commission of the United States Army. Number 5, decommissioning requirements. The applicant shall begin decommissioning no later than 12 months after the large-scale SES has ceased to generate electricity or thermal energy. All structures and facilities associated with the SES shall be removed within 6 months of the beginning and decommissioning. All materials shall be recycled or otherwise reused to the extent reasonably practical, and the disturbed areas shall be reclaimed, revegetated, and restored. Failure of the applicant to decommission a large area solar energy system in accordance with this ordinance and the applicable decommissioning plan shall be grounds for the county to invoke the surety instrument. The county shall be entitled to recover from the surety instrument proceeds that are necessary to complete the decommissioning of the facility. Furthermore, should the cost of decommissioning exceed the value of the surety instrument, the county shall be entitled to recover the excess amount necessary to complete the decommission process. In the event of a failure to perform, default, or failure to extend a surety instrument, the county reserves the right to take all applicable legal and administrative actions necessary to compel the completion of the decommissioning by the applicant. This includes securing all necessary easements and right-of-ways and are to recoup any public funds expended by the county in fulfillment of the application obligation. A failure to decommission a large SES facility as required herein is a violation of this ordinance and shall be subject to the enforcement and penalties as provided herein. Number 6, license revocation. The Russell County Fiscal Court Judge Executive may revoke a license subject to a 90 days written notice to the applicant upon the occurrence of one or more of the following. A, the applicant has provided false or inaccurate information as part of the application for licensure. 2, the false or inaccurate information should result in the siting, construction, and operation of a large SES facility in violation of this ordinance. And 3, the applicant has failed to correct the violation within resubmittal of the amended or approval application and perform any necessary site modification within the 90 days modification period. B, the applicant has, number 1, failed to construct to maintain the large SES facility in accordance with the ordinance and the approval plan. And 2, the applicant has failed to correct the violation within 90 days notification period. C, the applicant has, number 1, failed to decommission the large SES facility in accordance with the ordinance, and 2, the applicant has failed to correct the violation within the 90-day notification period. D, the applicant has, number 1, failed to submit or update decommissioning plans and accompanying revised surety instrument within the 5 years period as required by section 4D. And number 2, the applicant has failed to correct the violation within 90 days notification period, or E, the applicant has failed to transfer the license upon change of responsible entity in accordance with section 7 of this ordinance. Any license revocation issued under this section shall be recorded in the Russell County Clerk's office. within 90 days of the recording of the revocation of the license, the large-scale SES shall cease operation, and within 12 months thereafter, the decommissioned in accordance with Section 5 of this ordinance. Number 7, license transfer, notification, required exhibits. A change in or transfer of the responsible party ownership as contained in the large-scale SES application and accompanying license shall require the issuance of an amended license, which shall be so recorded in the Russell County Clerk's office no later than 30 days following the sale or transfer of a large-scale SES facility. The responsible entity that has or is assuming ownership shall provide within written notification to the Russell County Judge Executive Office, and shall submit the following information. A, the name and address of the current license responsible entity and the license number. B, the name and mailing address of the responsible party assuming ownership with proof of ownership. C, a statement that lease agreements are for participating property, if any, are transferable with accompanying documentation. D, a statement of conformance with the ordinance if SES enlargement are changed to the condition of the original application other than ownership is to occur. A new application as provided in Section 3 is required. And E, a revised surety instrument bearing the name of the new responsible entity. Within 60 days of the receipt of notification, the Russell County Fiscal Court shall, number 1, approve the issuance of an amended license, or number 2, deny the issues of the amended license with cause stated. 8, all other state and regulatory laws that are specifically addressed by this ordinance remain in effect. 9, severability if a portion of this act or its applications to any person or circumstances is held invalid. The invalidity does not affect other provisions or applications of the act that can be given effect without the invalid provision or application. And to this end, the provisions of the act are severable. Number 10, any person found in violation of this ordinance shall be guilty of a misdemeanor and shall be fined not less than $100 and not more than $500. Each day a violation shall continue to is a separate offense. And number 11, the ordinance shall be in full force and effect from and after its adoption and approval as provided below. First reading date, second reading of the ordinance date.
Thank you, could read that again.
What is that?
Read it again.
No, thank you. I couldn't if I wanted to.
All right, so we've had the second reading of the 2510 ordinance regarding solar farms / parks. So, what's your pleasure?
Judge, I'd like to just say, we've heard from both sides of the aisles here, and we respect everybody's opinion. And we've talked to lawyers, and we've talked to other counties. This is not the decision we just made, or that I made, all of a sudden. But at the end of the day, this court has to make a decision. We can't shove it off. And we have to make the decision what we think is the best for the people of Russell County. that's who elects us, and that's who we represent. So therefore, I make a motion, we pass this ordinance.
I second.
We got a motion by Magistrate Richardson and a second by Magistrate Skaggs.
Okay. So now the vote.
Could you do a roll call vote, please?
Roll call vote. Magistrate Skaggs.
Yes.
Magistrate Richardson.
Yes.
Magistrate Wilson.
Yes. What did he say?
Magistrate Waddell.
Yes.
Magistrate Garner.
I'm gonna abstain from it because I've been out with surgery and I wasn't here at the last meeting, so I'm gonna abstain my vote.
Motion passes for the ordinance to go in effect. Next on the agenda is the 2025 COPS Grant Award for $166,960 for one officer for 3 years for hospital security.
Make a motion.
Motion made by Magistrate Garner, second by Magistrate Richardson to accept that grant. All those in favor signify by saying aye. Aye. Any opposed, same sign. Darrell, sorry we kept you here so long, but these meetings usually go really fast. We kind of pride ourselves on being done in 30 minutes, so.
I may be the shortest one that you'll listen to today. I'm here on behalf of the Russell County Soil Conservation District, and once again, we're here to ask you and inform you a little bit about our dead animal removal program here in Russell County. 2003, just to toss some numbers at you, we handled 573 removals. 2024, we handled 569, and 2025 year-to-date. As of right now, we have handled 493 animals for an amount of $31,465, which we reimburse the livestock owner for part of his pickup, and plus that helps with the environment, helps with the water resources, the overall environment. In the past, you all have graciously give us $5,000. At this stage of the game, Russell County Ag Development District, as last Thursday, they gave us $7,500. And this is all about matching money, and you all know more about that than I do. But these matching funds are really, really important when we go to the state. And right now, when if you all go ahead and do as you've done in the past, we will have funds that we will go to the State Department and ask them for money to keep this program going and providing that service to the landowner. And if you got any questions, I'll be glad to try to answer them. And if you don't have any questions, I'm gonna sit back down and
We've been given 5,000 of it.
do
Is that
what?
what you're asking for?
We've been given 5,000.
5,000.
And that's what you're asking for today?
Yes, sir.
I'll make a motion.
Motion made by Magistrate Garner, second by Magistrate Waddell. All those in favor signify by saying aye. Aye. Any opposed, same sign.
Thank y'all.
Yes, sir. Road changes. We have any? Is everybody good on road changes? Okay. In other business, I've got two applications here to do ambulance, or I'm sorry, not ambulance, but towing service in the county. It's from the same person, just two different businesses. And the business, if you all want to see these, it's from Columbia. I don't know what your all's pleasure is on that, but
Don't we usually use the one from the county to start with?
yeah, I mean, I can do it however y'all want to put them in, and if there's somebody in Russell County can't do it, then call them or whatever, so. If you put them in a rotation, see how many we've got.
Nobody from Russell County can do it, call them, but as long as somebody from
I
Russell
think we
County
should
can do
just
it.
leave it to the Russell County.
Yeah.
Leave it.
What kind of response time would you get from?
It didn't say, actually, it's just our application that they do from dispatch, and it's got all the insurance requirements and stuff that we require to be a part of the, towing here, so, okay. So we'll let that be.
Use Russell County first.
I don't have anything else. I don't, you have it?
I just have that one paper.
Alcohol sales. Yeah, that's what I need. Let's do what it is. Alcohol sales for September received in October was $11,677.18.
Make a motion to adjourn.
I'll second it.
Motion made to adjourn by Magistrate Garner, second by Magistrate Richardson. All those in favor signify by saying aye. Aye. Any opposed, same sign. I know that was laborious. Oh, hey, guys, listen, here's a piece of art, I forgot to recognize this. It was done by the gifted student, and his name is Ben Brown. It's about the bicentennial, so.